Welcome to Law Watch, episode 40, with former judge and author of The Return of Breaking Law, Stephen Gold.
Here's the judge! Here's the judge! Everybody knows that here's the judge!
There's a new act coming into force on the 6th of April 2024 for the benefit of workers. Pregnant ones this time, so no good to you, Mr. Lee, though he does look as if he's put on a bit of weight. This time it's the Protection from Redundancy, Pregnancy and Family Leave Act of 2023, which we've dipped into on a previous video. The Act extends redundancy protection, that's the right to the offer of a suitable alternative vacancy when one arises, so it applies during pregnancy. In fact, from the point at which the boss is informed of the pregnancy, and the right will continue for workers who've recently returned from maternity leave. And adoption leave also, all from a period of 6 or more weeks of shared parental leave. Off to an employment tribunal if the boss doesn't follow the new law. For babies born after the 6th of April 2024, there are paternity leave changes. Currently, fathers and partners can only take their paid leave in one block of a week or 2 weeks. In future, they'll be able to take 2 consecutive weeks of leave. Also, they'll be able to take their leave and pay at any point in the first year after birth rather than in the first 8 weeks as at present. And there'll be a shortening in most cases of the period of notice to be given to the employer that leave is required. For example, from 14 weeks before the expected week of birth to 4 weeks before each week of leave. Changes are also made where leave is to follow a child placed for adoption on or after the 6th of April 2024. Meet company law reform.
On the 6th of April 2024?
No, smart ass. Actually, they came in on the 4th of March 2024.
Then shouldn't they have been covered in last month's videos?
Oh, that's a fair point, actually. I'll get him for that. Do you know of a good video producer? One who's respectful? If you want to stay up all night, then have a read of the Economic Crime and Corporate Transparency Act of 2023, which has 92 sections, as stimulating as a telephone directory. But if you are an officer of a company, you need to know about some of those 92 sections that are now in force. First of all, and this will also interest anyone who has an unpaid court judgment against a company and is wanting to hunt it down, having a postbox as the registered office of the company is now a no-no. You should change it immediately. This can be done online. If you don't, Companies House will change it to a default address, and then if you fail within 28 days to notify an appropriate address, the procedure to have the company struck off will commence. To be an appropriate address, it has to be one where any documents sent to it can be expected to come to the attention of a person acting on behalf of the company, and where any documents sent to that address can be recorded by an acknowledgement of delivery. The top branch of a tree, which is only visited by the company's auditor once a year, well, that won't do either. Secondly, when a new company is incorporated, it must now provide Companies House with a registered email address, which should boost computer sales, but the address will not be published on the public register. That's enough.
Thank heavens.
The Ombudsman, the Financial Conduct Authority, they're going to have a complaint or two about Car Finance Commission, are among my favourite. No, we don't take wine together, especially when they find in my favour. The limits of the compensation awards they can make are reviewed every year in line with the Consumer Prices Index, and since that always goes up, the compensation limits go up too. Well, this year's review has now been completed. If you are complaining about something a bank, building society, broker, whoever happens to be regulated by the authority, something they've done or not done on or after the 1st of April 2019, and you wait until on or after the 1st of April next month, then the compensation limit available will be £430,000, which would do nicely. It was £415,000, so an extra £15,000. And if you apply from next month for a misdeed perpetrated before the 1st of April 2019, which would probably be exceptional, the limit is up £5,000 from £190,000 to £195,000. Incidentally, when you make a complaint to the Ombudsman Service, they will ask you whether you complained before. If you have, they'll look you up. And if they've got a dozen previous files for you, I wonder what they say.
How nice to hear from them again.
More likely, not that again. And while on the subject of ombudsmen, where you stand to get justice without having to launch a civil court case, and it's all decided on paper and it's free, my more favourite one is the housing ombudsman. He mainly deals with complaints in the social housing sector. His latest awards against Lewisham Council, a total of £40,000 for tenants of 3 dwellings for damp and mould, and against Peabody, a total of around £11,000 for the tenants of 4 dwellings, arising out of allegations about complaint handling deficiencies, adaptations and overdue repairs. There have also been findings from him this year against Birmingham City Council in 6 cases because of inaction over leaks and vulnerable residents being left in damp and mould, and against Hammersmith and Fulham for multiple and repeated failures. And just hot off the press, the Housing Ombudsman has announced 4 findings of severe maladministration against the Guinness Partnership, fungi growth, and a child living in damp and mould for 3 years. They were among the Guinness failings. So if your social landlord is Lewisham, Peabody, Birmingham, Hammersmith and Fulham, or the Guinness Partnership, or whoever, and you've got a justified complaint, hello, Housing Ombudsman. No, I'm not on commission.